This is Michael Popok, Legal AF. I started to do a hot take about the impact of the Pennsylvania shooting on the existing criminal cases against Donald Trump. And while I was doing the hot take, we got the first one. Mar-a-Lago, Judge Aileen Cannon has decided after the shooting and before the convention to dismiss the indictment against Donald Trump because she found that the special counsel's office was improperly appointed by the Department of Justice and is illegal, and therefore the money that's been used to fund him also improperly apportioned. It's a fringe theory that's been a zombie theory floating around within the MAGA ultra right wing. It was expressed by the Landmark Legal Foundation, which is again a MAGA ultra conservative right wing foundation and supported by Judge Cannon. Let me now explain what I think the impact has been of the attempted assassination of Donald Trump in Pennsylvania on the criminal cases against him. Let me start with Mar-a-Lago. I'll end with D.C. and New York and walk you right through it. Originally, I was going to talk about the impact on the jury pool and jury selection for cases that are left to be tried. And I'm still going to talk about that. I got some background on the impact of mass shootings or shootings on jury selection. Unfortunately, I was in Vegas after the Harvest Festival shooting and had to pick a jury right after that. We'll talk about that in a moment. The headline, and we've done it on Legal AF and in a special segment that's already up on a hot take, is Judge Cannon has decided to drop her 93-page decision in which, in our view, she inappropriately analyzes the language of the various congressionally approved statutes, which have always been interpreted by every court that's ever faced it, except for Judge Cannon, to empower the Attorney General, who is ever sitting in that Attorney General seat, Republican or Democrat, appointed, to appoint a special counsel or a special attorney to work under them, not to Aileen Cannon. In fact, in the 93 pages, she so quickly dispatches the arguments by the special counsel as almost to act like they didn't exist. You might be wondering, what did she write in 93 pages? Well, I'll tell you what she didn't write. She didn't write a proper analysis of the legislative history behind each of the statutes that go to whether special counsel is properly appointed or not. She spent the rest of her time just adopting fringe arguments of right-wing MAGA conservative briefing that she allowed to be sent into the court and that she allowed to come in as strangers and argue in front of her at a hearing a few weeks ago. That's how much of a sandpaper relationship she has with the special counsel's office. You could tell there's been tremendous frustration by the special counsel's office, and now finally on a 93-page decision, which is wrong, they have an ability to go right to the 11th Circuit, the Court of Appeals, the bosses for Aileen Cannon, and try to get her reversed. But that, of course, is going to take time, depends upon the briefing schedule. We know that the special counsel is going to appeal that in the next day or so, and we'll get a briefing schedule set by the clerk of the 11th Circuit. We'll know if they're taking it seriously in terms of, is it going to be a normal 6 or 8 month schedule of briefing, or is it going to be a very short amount of briefing? We're going to find that right away. But look at the impact of the shooting. I mean, 2 days after the shooting and on the day of the Republican National Committee, the Cannon drops her 93-page decision. I mean, it is, you can't believe it. I mean, I'm not a conspiracy theorist, but there's no doubt that she was impacted, the judge, by the political calendar in this. If she wanted to avoid the political calendar, she would have gotten several weeks beyond the shooting and beyond even the convention and then made her decision. But no, she's given Donald Trump a gift on the way in, although I would argue, and we've argued, it's also a gift to the Department of Justice and their ability to finally not only appeal her, but seek to have her removed through a reassignment process because she's made so many fundamental mistakes in the case, including before there was even an indictment when she tried to interfere with the criminal prosecution by the Department of Justice. That's the impact on that case. Let me move now to the Chutkan case. The Chutkan case, Judge Chutkan presiding, D.C. election interference, 4 counts against Donald Trump. Now, it was sent back to her on July 1st by the immunity decision by the United States Supreme Court, 6-3, telling her she needs to go through the indictment and the overt acts and decide which are absolute immune because they're core presidential powers from the Constitution, which are presumed to be immune with almost an impossible burden for the special counsel to overcome if it's official conduct stretched to its outer boundaries, and which is prosecutable crimes because it's private or unofficial conduct. That's what the hearing was supposed to be about. That was going to be sometime in the first week in August. Now we're going to have a motion being filed off of what Judge Cannon just did to dismiss because the special prosecutor in Trump's view is illegitimate. And now that issue is going to be in front of Judge Chutkan. She also has to worry about the shooting's impact on a potential jury pool. Whereas the prosecutors were in a rush to get the case tried before the election and to let the American people know about the impact of the jury verdict on their decision-making, that it was important that the electorate know about whether Donald Trump was a convicted felon or not. Now they have to worry even if they overcome the motion to dismiss the dismissal because the special counsel is inappropriate, now they got to legitimately worry about the impact on the jury pool. How does this, it will, I guarantee you, it will impact the jury pool one way or the other. It will not be an agnostic event that has no impact on the jury, the shooting of Donald Trump. It may benefit him. It may be to his detriment. If I had a guess, it will create a sympathy factor for the jury. And the closer in time the jury selection is to the shooting, the more advantageous it is to Donald Trump. In any event, if you're trying to administer fair and impartial justice in a courtroom, which is Judge Chutkan's concern, you got to think about maybe we need a delay, a cooling off period, because emotions are running so high on both sides after the shooting. So now you might see the prosecutors and Trump saying, even if we get this case back up and running in the next several months, because the judge said originally, I'm going to get this case up and running by the end of the summer, maybe the beginning of the fall. Maybe there needs to be an additional delay that's baked in because of the waters being roiled around the shooting. So that has an impact. Again, you also have this new wild card factor of a federal judge, not an appellate court, but a federal judge has dismissed an indictment prosecuted by the special counsel, finding that he is illegitimately appointed. Now going to be back in front and center in the DC case. The older I get, the more I find myself wanting to be more intentional about the way I live, eat, and take care of my body. Mosh, which you may have heard about on Shark Tank, was founded by Maria Shriver and her son, Patrick Schwarzenegger. And they have a simple mission: to create a conversation about brain health through food, education, and research. Mosh joined forces with the world's top scientists and functional nutritionists to go beyond your average protein bar. With 10 delicious flavors, including 3 that are plant-based, each Mosh bar is made with ingredients that support brain health, like ashwagandha, lion's mane, collagen, and omega-3s. Mosh is now the first and only food brand boosted with Cognizin, a premium nootropic that supplies the brain with a patented form of acetylcholine. Look, I can truly say Mosh bars taste heavenly, and I've been loving their banana bread bars. The energy boost these bad boys give me in the morning is unparalleled. With the fresh kick of energy and brain health supporting supplements in their fresh formulas, you can bet I'll be coming back to them. If you want to find ways to give back to others and fuel your body and your brain, Mosh bars are the perfect choice for you. Head to moshlife.com/legalaf to save 20% off plus free shipping on either the Bestsellers Trial Pack or the new Plant-Based Trial Pack. That's 20% off plus free shipping on either the Bestsellers or Plant-Based Trial Pack at moshlife.com/legalaf. Thank you, Mosh, for sponsoring this episode. Now let me turn to Georgia. I don't see the shooting having a major impact on the Georgia prosecution of Donald Trump, because that case is sort of on ice and has already got a built-in delay of several months, well after October or November, because of pending motion practice before the second level appellate court in Georgia, or the first level of appeal, which is their court of appeals, which is below the Georgia Supreme Court. There's a motion to There's a motion to dismiss the appeal brought by Fani Willis, the Fulton County District Attorney. Sorry about that. And that has not yet been ruled upon. She's arguing that there is no proper appeal and the whole thing should be dismissed. Donald Trump's people are arguing that the decision by the trial judge McAfee to not dismiss the case because of a conflict of interest or an appearance of impropriety or ethical violation by the prosecutor was improper. So that issue, though, is months away from being decided. And thereafter that, the jury selection is going to be a 2025 event. So I don't see the shooting and any kind of sympathy factor or factor one way or the other against Donald Trump impacting Georgia. Now let me end the hot take with New York. New York, there's already been a conviction. So it's not going to impact the jury process. But the motion to dismiss under the immunity decision is going to have to weigh on the mind of Judge Merchan, and he's already delayed the sentencing of Donald Trump until well into September and perhaps beyond, depending upon the results of the briefing on whether immunity applies. And the focus on the immunity decision is, even though almost all of what happened in the prosecution and the indictment was before Donald Trump was president in 2016, in his cover-up of the sex act with Stormy Daniels in order to get elected, there were payments and invoices and some strategy meetings after he became elected. And so the question is any of that official conduct, was any of that evidence presented to the jury, which shouldn't have been, because the immunity decision says no official conduct can ever be used as evidence in your case, even in a case involving unofficial conduct. Of course, this is a little bit of a horse of a different color, because this is a case about prosecutable crimes of a person that was not yet president, and then some official conduct about certain of the acts. And I think on balance, as we've said on Legal AF before, any of the evidence about the short time that Donald Trump was in the White House in concluding the conspiracy, and a couple of pieces of testimony, straight pieces of testimony from his press secretary and from the person responsible for scheduling his meetings, is what we call harmless error. The fact that that information, that evidence went to the jury, even if it was improper, is not the reason they convicted Donald Trump. It's all the dozens of other witnesses, including Michael Cohen, Stormy Daniels, people that worked for Donald Trump before he became president. You got David Pecker, the head of the National Enquirer, the Trump Tower conspiracy. That is why, that is the basis for the conviction, not some straight testimony about how Donald Trump schedules his luncheons. And so I think that's the ruling, and there'll be no impact on Judge Merchan of the shooting, one way or the other. He's just a sober, mature jurist. He's not going to let that impact his decision-making, and there's no jury to pick. So I think I started this hot take talking about what is the impact of Pennsylvania and the events there on the various proceedings. We're already seeing one in that I think that if Judge Cannon, I don't know, I'm not thumbs-upping Judge Cannon. It was just an inadvertent act there. But if it's obvious that Judge Cannon was already leaning and bending over backwards in favor of Donald Trump, and that the shooting was only going to push her completely over the edge, and now let her hit print and send on a 93-page order adopting a fringe theory moments after the Pennsylvania shooting and moments before the convention started in Milwaukee. So you're already seeing real-world impact of the Pennsylvania shooting. We'll continue to cover it all on Legal AF at the intersection of law and politics right here on the MeidasTouch Network every Wednesday and Saturday at 8 p.m. Eastern Time on Legal AF, our leading podcast at that intersection, and then on hot takes like this one about every hour. Give me a thumbs up and leave a comment. It helps keep us on the air. It helps with our ratings, if you will. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.